Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay, here we go. How is everyone? Hi, Tammie. Hi, Gizzy. Hi, Maestro. Thank you for moderating. Angela, Fraud, Susan Hicks, Tanja, Chris. Hello. Today on the docket, Karen Reed's defense team really got exposed by Hank Brennan. I went over it a little bit last night, but I think some of it bears repeating because what he was talking about, now he's arguing about a pattern of the defense leaking information through their filings, through their arguments. So it may not have anything to do with their argument, but they're going to leak information in an unrelated filing. So we saw this when they were asking for their forensic expert to be reimbursed. There was a whole lot of information leaked in that filing that had nothing to do with his reimbursement. And just to rile up the Free Karen readers. So the Free Karen Read fraud, innocence fraud, has really been exposed. So they haven't always done it that way. Sometimes they've leaked information to Aiden Turtleboy Carney, then referred to Aiden Turtleboy Carney's reporting in their own motions, meaning their own filings to the court, and as it's been reported. But they're the ones who leaked the information. It would never have been reported had they not leaked the information. So it's a big no-no in lawyering. They've overstepped the line so many times. So I don't mean to be too much of a doom and gloomer when it comes to the gag order that we now have on the lawyers. Of course, Karen Reed is free to talk. We have a ID discovery. It really looks like a mockumentary. They've embedded themselves with Karen Reed's defense team. I'm going to talk a little bit more about that on Tuesday. Coming out. So they've fed the mockumentary team a whole bunch of nonsense that's going to be disseminated out into the public, including the jury pool. So I just wanted to show how, now to explain a little bit about what Hank Brennan was talking about when he was arguing to the court about how all these statements in court and outside of court are like, it goes beyond advocacy for their client. The statements done in court are part of a smear campaign, a propaganda campaign meant to fool a gullible public, because these lawyers know that they cannot win in court. They can't do it. Just think about the evidence that was presented to the jury in Karen Reed's defense, and eliminate the innocence fraud campaign that was hinted at and brought in. We have the ARCA experts, who we now know were bought and paid for by the defense. They were given a limited amount of information. This is something that Adam Lawley brought up over and over and over again. I don't know if anyone heard him. He was on cross-examination. He said, and to Judge Cannoni, these are witnesses that never asked for any material from the Commonwealth. They only took material handed to them from the defense, and they didn't ask for more material. And they even said in cross-examination, had they had more material, it wouldn't have changed their opinion. I mean, if that doesn't expose you as a shill, I don't know what does. Some jurors were obviously listening, because according to Ronnie, the juror, some jurors, and he was laughing at them, felt that ARCA was paid by someone and that they couldn't be trusted. Then you have Marie Russell, a true crime retired emergency room doctor, true crime fan, emergency room doctor, tension-seeking woman who has a hobby, which is an interest in bite and hold wounds from police dogs. Hardly a dog bite expert, but okay. Her testimony was terrible. And Richard Green, who admitted on cross that his findings Cellbrite had to change their program due to his findings. His wrongful reading. I like to call him Richard McNasty's Green, because he had criminal charges from an incident at the McNasty's bar where he falsely accused people of hitting him. He had to plead out. I mean, it's like, it's a crazy bunch of defense witnesses that can't prove their case. And how could they prove their case, the defense, when they don't even know what their case is? They have no cohesive story. They have no alternative suspect. And they really can't poke holes in the Commonwealth's case besides saying, oh, why did you use solo cups in a nor'easter to collect evidence instead of proper evidence collecting gear? It was pretty inventive, in my opinion, and resourceful. Was it ideal? No. But I ask, what would the Free Karen readers have done? And the Sallyport video is mirrored as it was a month before. That's the way they took the Sallyport video. It was always mirrored. It was always recorded mirrored. So they can't prove their case. There's not much. And this is why all innocence fraud cases are played out in the court of public opinion, to so that they can put pressure on the courts and can manipulate the courts in really sleazy ways, pressure judges, etc., pressure DAs, because DAs, of course, have to be reelected or elected to, either overturn a conviction or set someone free. Or in this case, the point of this innocence fraud campaign was to get the charges dropped before they ever went to trial, which is David Yanetti's specialty. If you've watched some of my other videos, I've gone through his website, and there's case after case where cases have been dropped. So let's listen to what Hank Brennan was saying about how the defense worked, how they created this smear campaign, propaganda campaign of terror against witnesses, against anyone who would speak out against this. I mean, I can't tell you. I mean, this is so minor, the pushback I've felt on my channel and on Twitter, the personal insults, the "you're a see you next Tuesday" kind of thing, for just stating my opinion about Karen Read. And the point of that is to get everyone who believes Karen Read is guilty, including the witnesses, including the victim's family, to be quiet, especially the victim's family, because they have the most powerful voice, always. So let's start off by listening to the last hearing in the Karen Read case. Hank Brennan, here's his oral argument. Let's take a listen.
The court. I'm not tone deaf, but it is a claim that was lodged that has collateral consequence. And I think it's important for me to be able to address it. May I?
Yes.
The claim of jury tampering is probably one of the most serious claims that one can make, because it's not simply an attack on a case. It questions the fabric of our entire judicial system. If a good juror comes to court and believes there is no integrity in the court or in the judicial system, it is impossible for a fair-minded juror to even consider evidence because they do not trust the system to begin with. And if a government...
And what a benefit of an innocence campaign. So here's Hank Brennan saying, if a fair-minded juror comes to the court and already is distrustful of the system, they're not going to convict anyone in a kangaroo court, in an unjust system. They're going to naturally be sympathetic towards the defendant. And this is what has happened in the past, I'd say 20 to 30 years. We've seen more and more media, more and more news stories about wrongly convicted people. They never go into the transcripts. They never talk to the victim's family. They never talk to the original prosecutor. Often the original prosecutor is dead. They don't do their due diligence. And what we get is this one-sided reporting about a wrongfully convicted guy who was freed and how wonderful it is. And you shouldn't, and he was wrongfully convicted for, they always started out the stories this way. They were wrongfully convicted for a crime they did not commit. It's like a refrain that it's like an endless loop playing in my ears. I've heard it so many times. So the point of that is to make it easier for defense attorneys like David Yannetti, like Alan Jackson. So when you have a juror who comes to court, well, I've seen all these episodes about wrongful convictions. They're so easy and so common. Never mind that 99.99% of them are frauds upon the court. Never mind that. I've seen it. I've seen documentaries. I don't want to be the person to wrongfully convict them. What if this prosecutor may be dirty? They may be up to something nefarious, and it goes hand in hand with a war on the police. Police are, and I'm not saying that there aren't bad apples in the police and that they're all wonderful, but certainly every time that there is any questionable activity, and how many times have you seen news stories and protests come out and claiming egregious conduct only to have the body cams appear, and it's nothing like what is said in these campaigns. Video's nothing like it. And boy, that shuts down that campaign very quickly. So it works hand in hand. Can't trust the police witnesses, because so often can't trust the police, then you can't trust their testimony in court. Who would trust their testimony in court? If you've seen 50 to 100 news stories about how terrible and corrupt the police is. This is what Hank Brennan's talking about.
Actor or a trooper or a police officer tampered with a jury, that would be one of the biggest, most abhorrent transgressions that could happen. Because of the collateral consequence of tampering with the jury, it would take away the community's belief in our system. On the other hand, if there is a claim of jury tampering and it's baseless and there is no evidence, it is not only a direct attack on the judicial system, it would seem to be an effort to try to undermine the authority of the system in court before a trial to impede the ability to have a fair trial. It is an extraordinary claim. And it's notable, the defense motion to dismiss is not just a motion to dismiss, it's a motion to dismiss for extraordinary government misconduct. So when you make an extraordinary claim about jury tampering, there should be extraordinary evidence. There isn't even ordinary evidence. There is no evidence of jury tampering in this case. Now, I don't want to belabor this, but it's important because of the consequence of what happens when a claim like this is lodged. There is damage.
So he's saying there's not even a little evidence, but it's in a court filing. Lawyers wouldn't say it if it weren't true. But it's not, they would have to put it in their filing. They would have to have evidence of it. And of course, they're not supposed to lie and make things up in filings. But this is a habit of Karen Reed's lying defense lawyers. They make things up, they put them in their filings, and everyone goes, oh, well, something must have happened, or a lawyer wouldn't have said it. Like I've said before, we treat lawyers as if they are, little under gods, just like doctors and other experts.
Then why I'd rather sit down, as I said before, a lie unchecked becomes the truth. And so how does one propagate a claim of jury tampering when there's no evidence? Well, first you need to plant the seed of corruption. And all you have to do is whisper it and hope the poison goes out there and is resonating in the potential community. And so what happens in this case? The defense finds a willing partner who covets an opportunity to meet with the defendant. They find a time, like after the Super Bowl, so there's this national exposure, and they just seep the information. They just seep it into the public and let it resonate. There can be no retort. The government can't respond. No facts, no evidence. Just saturate the public. Now it's important.
Right. And that's why it's so important that they get out as many people as possible. People have said to me who have familiarized themselves with some of these cases, and part of this episode is imploring you to look beyond true crime media and dig into the court transcripts. Never believe have some skepticism. Never believe a documentary, quote unquote, on its face. There are all kinds of biases and motivations, and this is a movement to get out as many people as possible to saturate the public with this wrongful conviction media, so that we think that wrongful convictions are a common, frequent occurrence. I mean, people have said to me, do they pick the guiltiest people on earth to champion as innocent? What's going on? I've checked out these court transcripts. No, they just went out as many people as possible. And the longer they've been in prison, the better. The prosecutor might be dead. Witnesses have died. Memories have faded. Memories of the horror of the crime. Memories of the victim. Victims' families members have died. So when you see someone getting out 27, 30 years, 40 years, your eyebrow, who was quote unquote wrongfully convicted, even if there's someone else taking claim for the crime, your eyebrow should be really raised. You know, I reported on a case in San Francisco, from the Southern California Innocence Project, where a Innocence Project lawyer had romanced a man in jail for another crime he was doing life. It wouldn't have mattered if he had taken responsibility for her client's crime, and also offered him some of the wrongful conviction money that comes with the civil suits. All this was exposed. Do you think it was national news? It's a tiny story in a tiny paper. So, and they're trying to sanction that lawyer, and good luck with that. And he also, because when this guy got out and he won the biggest settlement, that I think it was the second biggest or one of the biggest settlements that area had ever seen. I think it was $12 million. That's my memory. Don't quote me on that. They gave none of the money to the convict who was being romanced. And that's when he went public with all his text messages and communications and sexy pictures from this Innocence Project lawyer. So I just want you to have some skepticism about these cases. Point is to disparage our criminal justice system so much that when guilty people come to trial, they won't get convictions. To really stop convictions before they happen. The other motivation, obviously, is money, is to win in our civil courts and get these multi-million-dollar payouts, most of which some of the killer gets, but mostly it goes to these lawyers. And thirdly, the motivation is to push an ideology, which is that we have to reform our criminal justice system because it's so broken and unfair, and make shorter sentences like they have in Europe.
It's important to see or hear or read what is said, because this really is the acorn that is being planted that cannot be rebutted. And it's not insignificant that this same information before this interview is being disseminated by Mr. Kearney. This idea that there was tampering by Lieutenant Fanning. Not a coincidence. And so during this interview that the defendant and the attorney have, the questions asked, I don't know why it's asked, but it's asked. There have been sort of these unsubstantiated claims in the atmosphere that there might have been some funny business with the jurors who were dismissed. Really? And Mr. Jackson says, right. The question, is this a real concern that you have? Is this something that you are looking at, or have you just dismissed it as a rumor? Answer, I never just dismissed that as rumor. Something like that, it's too convenient for the prosecution for us to just dismiss out of hand. Do I have any evidence, specific evidence that there was jury tampering? I don't have any specific evidence of it. And yet we have a motion filed 2 weeks later.
No evidence of it, and yet there's a motion filed. And yet they say it's too convenient for the prosecution to dismiss it. But really, again, as they always do, the projection is off the charts. It's too convenient for the defense. It's a rumor they started, they're going to use. And it's very convenient for them to use, for them to dismiss it. It's too convenient for them. They have nothing else. There is no other story like the Commonwealth's theory on this case that all fits together from beginning to end for Karen Read. It's a mismatch for them, depending on which story you want to believe, and that's why Karen Read has told so many stories.
Do I think there are questions that should be asked? Do I think that there are questions that have been raised about the way the jurors were dismissed and who was dismissed very specifically? And then it continues on page 13 of the transcript. Question. One of the state troopers who was involved with the Norfolk DA's office and on the periphery of the investigation was also responsible for the jury. Not sure where these questions come from. Answer, right. He wasn't that far on the periphery of the investigation. He was involved in the investigation. He was direct supervisor over the individuals that were testifying and over and about whom we had leveled some very, very serious claims and ended up proving those claims during the course of direct and cross-examination in the presentation of our case. That person, that supervisor, we found out well in the trial. As a matter of fact, at the end of the trial, we found out is the very person who was governing the jurors. That's a question that should be raised. That is an issue that should be teased out. Should never, ever happen. That is the very definition of a conflict of interest. Question, is that standard in Massachusetts for just the DA's office to assign whoever they want to be sort of, supervisor of the jury? Yeah. Is it standard in Massachusetts? I hope not. Never seen that in my life. But if I had a nickel for every time I said I've never seen this type in my life as it pertains to the Massachusetts justice system, the criminal justice system, I'd have a lot of nickels.
Okay, so I'm just going to leave it there. I think you get the idea. He's talking about how they worked in these motions, putting ideas out into motions. We saw, of course, in Judge Cannoni's filing, that not only were they, hold on, let me just check my, hold on 1 second. Not only were they throwing out these filings, they were giving information to Gretchen Voss. I'm going to read it one more time. Here we go. The court also notes that Attorney Jackson had a conversation with Gretchen Voss. Okay, this is for her article. This is how we know that one of the reasons that she fought for her notes and unredacted tapes to be kept out of the second trial, just as it was kept out of the first, because all this is embarrassing, that she was basically a collaborator in this. I would call her an accomplice in this innocence fraud campaign. Attorney Jackson had a conversation with Gretchen Voss at the Omni Seaport Hotel, during which he revealed information that had been turned over by the Commonwealth in discovery but not yet made public. In that discussion, Attorney Jackson acknowledged to the reporter that he was not permitted to disclose the information that he received in discovery, and told her she could not publicly disseminate the information until it was put in a court motion. So here's the thing that I'm going to put in you're not supposed to have. But have your article on the ready. As soon as I put in this motion, your article will be there. So if people aren't reading my motion, they'll read your article and they'll get the information that way. How many things do you think were leaked out? Do you think this was the only time that Karen Reed's defense team leaked out privileged information, things that sealed information, things that should not have been leaked to journalists, and then put them in motions, or leaked out imaginary theories and then put them in their motions? Leak them out to Turtle Boy. Turtle Boy would write about it, then they would put them in their motions. So it can either work before, they leak it before, hold off on that article until my motion comes out, or, hey, Turtle Boy, here's some information, write about this. He writes about it. Then they're writing about it in their filings as it's been reported as. Attorney Jackson then proposed a way to make the information public in an unrelated court hearing so the reporter could put it in her article before publication. You think Gretchen Voss was the only one who was given that privilege? Let me know what you think. But here is Aidan Carney's lawyer. So when he was not allowed to join Karen Reed's team, I wanted to add him. Here he is saying he's been helping Karen Reed's team. This is from Grant Smith Ellis's Twitter. Thank you.
Judge, that the Karen Reed issue is a live question, whether or not there's a joint defense umbrella on that.
Do you have a joint defense agreement?
We don't have an agreement, but there's an implicit, there's been an ongoing long-term implicit mutual assistance and mutual defense that I myself have been a part of for a long time, and Attorney Bedrow has as well. And it's an issue that is not able to be worked out.
I really have no idea what that is. That means
I'm sorry, that was Tim Bradle. So Tim Bradle and Betterow have been helping out Karen Reed's team, and Karen Reed's team has been helping out Turtle Boy. This is the symbiotic part of the symbiotic relationship that Hank Brennan referred to. So if you haven't seen Gretchen Voss, and I think why Gretchen Voss, was really championed by some people on this side of the fence as the first person who wrote a guilty piece, or, I didn't read her piece in Boston Magazine that way. I read it as an innocence fraud piece. I know Innocence Fraud Watch blog also read it that way. And I just wanted to go through her excellent blog which has been updated, about Gretchen Voss. I think it just needs repeating. Make no mistake, Jersey girl Gretchen Voss, via Boston Magazine, and her amazing fact checker, Makina Guerra, were gaslighting and shilling for cop killer Karen Reed and perpetuating innocence fraud. There are around 400 codes covering journalistic work around the world. While various codes may differ in the detail of their content, excuse me, I had a cough. While various codes may differ in the detail of their content and come from different cultural traditions, most share common elements, including the principle of truthfulness, accuracy, and fact-based communications, independence, objectivity, impartiality, fairness, respect for others, and public accountability, as these apply to the gathering, editing, and dissemination of newsworthy information to the public. So here's Gretchen Voss saying, just joined X, but have been reporting this story since late May. My first article came out in October, link in bio, and I've been around and asking questions all along. No time off, just not into the social media nastiness. On May 11th, 2024, during Karen Reed's first trial for her murder, Aiden Turtleboy Carney leaked the following messages from Gretchen Voss to X. Aiden Carney, at Gretchen Voss. Okay, so it means Gretchen Voss decided to get ratchet with me today in the media line. Here's what she really thinks of the O'Keefe family and the Dougalls, who are also friends of John O'Keefe's, But that was before David Traub got to her with his burger. Okay. So she says, the Jersey girl in me was this close to asking Carl, that's Carl Dougal, who was John O'Keefe's friend, who spent the entire hearing staring at me and rolling his eyes excuse me. Let me start again. Yep. The Jersey girl in me was this close to asking Carl's wife, who spent the entire hearing staring at me and rolling her eyes with this disgusting smirk on her face, to take it outside. She wasn't so tough with you after. Nice work, all between us. And then she says, by the way, the hostility directed at me, this is Gretchen Voss talking to Aiden on text message, She says, by the way, the hostility directed at me from the O'Keefe side at court was insane. I had introduced myself to Carrie before, and she said they wouldn't speak to me if I was writing about the blogger, dagger stares, even from Mrs. O'Keefe. Know who the huge, and don't know who the tan, they're talking about tan guy. But the O'Keefe family knew that she was, at least Mrs. O'Keefe knew that she was not trustworthy and shilling for Karen Reed, but it goes on. There's more evidence of her having a strong bias towards Karen Reed and Karen Reed's defense and writing things that weren't factual, but were things that Karen Reed told her in order to make her article look like it was more a mystery as to what happened, as to how John O'Keefe was murdered. Carl Dougal was one of John O'Keefe's best friends and former Boston Police Department partner. One of the biggest ingredients of innocence fraud phenomenon is using writers or media outlets to fabricate a leading narrative. John Collins, who I've interviewed, check out that episode. It's called The Wrongful Conviction of Forensic Science, wrote about innocence fraud in his book, Crime Lab Report, stated in 2014, a common thread in many exonerations, quote unquote, is the use of willing journalists to front load a post-conviction investigation with the construction of a compelling innocence narrative. Indeed, this can be a problem in typical criminal investigations, where the press jumps to conclusions about a suspect's guilt. But in post-conviction litigation, the passage of time makes it easier to sell the alternate story as being legitimate. The same applies to willing journalists who choose to shill for accused killers, especially when their case has yet to be tried in a court of law. Here's Gretchen Voss in blue pants and a white vest top standing opposite Norfolk Superior Court in denim mask, referring to July 13, 2023, Beverly Canoe made the following statements in a footnote on her March 5th, 2025 memorandum of decision and order on Commonwealth's motion to impose sanction pursuant to mass criminal P48 and oral motions to prohibit prejudicial extrajudicial statements of counsel. The court also notes that Attorney Jackson, okay, this is again, I'll repeat it again. The court also notes that Attorney Jackson had a conversation with Voss at the Omni Seaport Hotel, during which he revealed information that had been turned over by the Commonwealth in discovery and had not yet been made public. In that discussion, Attorney Jackson acknowledged to the reporter, Gretchen Voss, that he was not yet permitted to disclose the information he had received in discovery and told her she could not publicly disseminate the information until it was put in a court motion. It is not yet known if Gretchen Voss reported the above to the bar of board overseers of the Norfolk District Attorney's Office, or if she made the court aware of Alan Jackson's behavior. However, 9 days after her meeting with Karen Reed and Alan Jackson, Gretchen Voss attended the July 22nd Rolling Road Rally organized by Aiden Turtleboy Carney. So there's Gretchen Voss at the Rolling Rally. Gretchen Voss had published her story in Boston Magazine, and this is the story that we've all kind of heard a million times, and you don't often hear anyone go beyond it. If there's any evidence that wasn't mentioned in Gretchen Voss's story, people don't tend to talk about it. What motivated Gretchen Voss to write a story on a live murder case pre-trial where only snippets of the facts of the case were available, along with a wealth of speculation, innuendo, and gossip? At the foot of her story, Gretchen or someone at the magazine added the following: update September 27th, 4 p.m. 2 sentences in the story have been revised, one for clarity, one for accuracy. Court documents state that no one else had arrived at 34 Fairview at the time that Callan Albert left. An earlier version of the story characterized Jennifer McCabe's daughter as Callan Albert's cousin. Jennifer McCabe's daughter and Callan Albert are not blood relatives. What court documents were being referred to, and why were they not referenced by Gretchen Voss or Boston Magazine? More importantly, why have there been no updates from Gretchen Voss or Boston Magazine for accuracy and clarity since new information and facts have come to light? Gretchen Voss or a colleague craftily used the word clarity and accuracy in an attempt to manipulate her readers and suggest to the uninitiated of the very real innocence fraud phenomenon grift that the rest of Gretchen Voss's story was accurate. It wasn't, and still isn't. Why did Gretchen Voss choose to write her story 7 months before hearing some of the evidence presented by the Commonwealth during Karen Read's trial for her murder? In places like the UK, people like Gretchen Voss and organizations like the Boston Magazine could and would be held in contempt of court. So in the beginning of Gretchen Voss's story, she says in the beginning of her tale, that's the way, snow had just started to fall as John O'Keefe and Karen Read stepped into the Waterfall Bar and Grill on Washington Street, Canton's main drag, on a Friday night in late January 2022. At around 11 p.m., it was the couple's second stop of the night after visiting another popular local pub. Why did Gretchen Voss omit to mention the fact that Karen Read had been arguing with John O'Keefe all day via messages and a few phone calls, and that Karen had also been jonesing for an alcoholic drink by 2:38 p.m., as noted by John at 3:39 p.m. Below is what Karen Read sent to John O'Keefe in a message on January 28th, 2022. I'm going to grab a drink in a bit. Was the reason Gretchen Voss did not write about Karen Read's ongoing arguments with John O'Keefe because Karen Read chose not to tell Gretchen about these continued disputes? Or was Gretchen Voss told of the ongoing arguments but chose to omit them? And where did Gretchen get her around 11 p.m. time frame from? John O'Keefe and Karen Read were caught on surveillance camera leaving C.F. McCarthy's pub at 10:40 p.m. They did not enter the Waterfall Bar until 10:54 p.m. Why not? What were they doing for 14 minutes? So this is said by Alan Jackson, I believe. It's like a 5-minute walk. And there's a 14-minute period between, it took them 14 minutes to make that it was described as less than 5-minute walk. Took them 14 minutes to make that less than 5-minute walk from one bar to the other. What were they arguing about? What was the delay? Were they arguing? Was there another kind of holdup? What was going on? Did Gretchen Voss ask Karen Read about those 14 minutes? In the bar, Gretchen Voss also states, inside the bar, O'Keefe spotted friends sitting at a high top near the band, and he and Read walked over to join them. Surveillance camera footage actually showed the band were situated near the bar's entrance exit, and John O'Keefe immediately went off in the opposite direction to Karen Reed when the pair walked into the bar. Did Karen Reed give Gretchen Voss the false impression that she and John had walked into the bar and stayed together instead of immediately separating? John O'Keefe was captured on camera making a beeline for Brian Higgins, who was on the right side of a large table, while Karen Reed went to the left side of the table, pointing at someone as she did. So they have them together, but they really separated into opposite quarters. John O'Keefe goes off to Brian Higgins. Karen Reed goes to the left side of the table. Let's take a look at it.
Introducing the Ungun, the non-lethal self-defense platform. Lightweight and simple to use.
Unfortunately.
Easy to...
Oh, the federal law, you have
With
to
5
kill
seconds.
evidence in hydroxychloroquine because under the
That's
federal
so annoying,
law,
isn't
you
it?
cannot.
Okay, here we go.
I can ask you to pause right there. So, Sergeant, from that particular portion of the video, what
There's John O'Keefe on the right.
That portion of video depicts Mr. John O'Keefe walking in with the defendant gesturing to a group of people at the top of the screen, and then Mr. O'Keefe walking over and giving a hug to an individual that's part of the group.
So that's a big difference. Gretchen's story
Quickest
goes
way
on.
to smooth wrinkled skin.
Let me just see if I can
Moisturizer
stop
helps
this.
your
At the table sat O'Keefe's neighbor, Chris Albert, town selectman. Chris Albert was John O'Keefe's friend and former neighbor who John had seen earlier in the day. John and his nephew Patrick had gone to Chris's pizza shop for lunch. This was something the pair of them apparently did a couple times a week. John had also texted Chris that evening as they had made loose plans to meet up that night. Gretchen writes on, as the band played on, the mood was festive and upbeat. O'Keefe downed beers while Reed drank vodka sodas, lots of them. Karen Reed told Gretchen Voss during a recorded interview on July 13th, 2023, that she did not drink at the Waterfall Bar. According to the October 2024 renewed motion by the Commonwealth, Karen had stated to Gretchen, I didn't drink there. Karen had also stated, I didn't really drink at the second bar. I just socialized. Why didn't Gretchen Voss tell her readers that Karen Reed had denied drinking alcohol at the Waterfall Bar? The evidence suggests Karen Reed had one fireball shot, which is whiskey, and vodka soda in the Waterfall Bar, not lots of them. Surveillance footage camera caught Karen quaffing the fireball shot at 11:46. In a previous interview with Gretchen Voss on June 20th, 2003, Karen had lied and stated, like a vodka tonic every 40 minutes. Like a vodka tonic every 40 minutes, except it was like every 4 minutes. Surveillance camera footage from C.F. McCarthy's evidence the fact that Karen Reed was drinking a vodka unit on average about every 12 minutes. So I joke and say one every 4 minutes, but it's around 12 minutes. So my question is, was Gretchen Voss approached by the defense to write this story? And did she sell this story to Boston Magazine? I have a really exciting story for you, Boston Magazine. You know, this is it. How did she get this story? And why is Alan Jackson, why does he trust her so much to say that I can't tell you, but, you know, as soon as it's in a filing, you know, you can write about it. Here's the information, but wait till it's in the filing and then write about it. And why did Gretchen Voss fight so hard to keep the redacted portions of the tape? Originally, the Commonwealth didn't want any comments from the lawyers. It was Brennan who asked for the comments from the lawyers. And boy, are we glad now that he did. Or we would have never heard that comment from Alan Jackson. So it goes on. There's other things that she left out, omissions, things that are more favorable to Karen Reed. And this is a pattern by the defense in this case of using reporters, using it all feeds each other. The campaign, they feed the reporters, they feed the campaign through their filings, and if their reporters don't have a relationship with the defense, they see the Free Karen Reed campaign grow, and that's where they know they're going to get a big audience by writing things that are favorable to Karen Reed. They also won't be the subject of intense harassment. So when I was talking about the rolling rally, that's when they went to people's homes, stopped in their car and protested at different witnesses' homes, screaming, calling them murderers. And Gretchen Voss watched these witnesses being harassed, just came along for the ride. So let me just show you. Let me just make sure I can pull it up. They also leaked grand jury testimony, it seems, to Aiden Turtleboy Carney. And they're asking, and why this is relevant is because, hey, Dean Walker, always good to see you, Dean. Thanks, Eva. Consciousness of guilt argument by Hank is very important. It, as in the Adelson's case, goes to jury instructions. Great, good point, Eva. So it's going to be really important. Why I bring this up, why all this is important now, is that Hank Brennan is trying to get the phone records between Aiden Carney and Karen Reed. And I'm going to go over them in a second. Thanks, Eva. Thanks for keeping me on track. Appreciate it. Thanks for this super sticker. I just want to show you quickly. Here's Aiden Carney admitting he has grand jury documents. Take a listen.
I also have, by the way, grand jury testimony from Brian Albert himself in April of 2022. I also have, by the way, grand jury testimony from Brian Albert himself in April of 2022.
Where do you think he got that? Karen Reed and her lawyers. And I'm going to take a quick break. When I get back, I'm going to show you the argument they made to Lally made, actually. To seal up this and show you the relationship between Karen Reed, some of the harassment, go over some of the harassment Aiden Carney is accused of doing. All when we get back. Don't go anywhere.
Glass of wine. Roberta will be back in no time. podcast is listener-supported, so smash that like button and subscribe or become a patron for exclusive content if you are so inclined. Have something to say? Shoot Roberta a super chat. She will do her best to read it on air without delay. Now Roberta's back and ready to put the true back in true crime. Here's Roberta.
Okay, so I'm going to start here. This is from I think this comes courtesy of Grant Smith Ellis. He put this in his Google Drive. I appreciate it. And thank you. I appreciate not having it so stamped with his mark, so it's a little easier to read. As part of their trial by media strategy. So this is something that the Commonwealth argued, Lally argued, Laura McLaughlin argued, and it was rejected by Judge Cannoni because she said that she wouldn't put a gag order in place on extrajudicial statements because there was no trial date set. I mean, why does that matter? I don't know. As part of their trial by media strategy, maybe a lawyer can tell me why that's relevant, if at all. As part of their trial by media strategy, the defendant has sought to target the witness's credibility and character through the use of media and has encouraged the unwarranted invasion of witnesses' personal privacy, contrary with their obligations under Massachusetts Rule of Criminal Procedure, which necessitates the protection of personal identifying information and publicly accessible court documents and Supreme Judicial Court rule. Defense counsel failed to redact personal identifying information in their filings and strategically filed motions containing various witnesses' personal identifying information, names, dates of birth, social security information, addresses, and phone numbers. The statutory purpose of Massachusetts rule and Supreme Judicial Court rule is to prevent the unnecessary inclusion of certain personal identifying information in order to reduce the possibility of using such documents for identifying theft, the unwarranted invasion of privacy, or other improper purposes. Additionally, defense counsel filed records that identified a juvenile by name and published numerous post-mortem photographs of the victim to the media. Okay, so admissibility of autopsy photographs is left to the discretion of the judge. They sound, and autopsy reports are medical files or information exempt from public disclosure. There's two. Defense counsel has failed to sustain their burden of proving their non-compliance with SJC Rule 124 and Massachusetts Rule of Criminal Procedure was inadvertent. So they're saying exactly what Unetti argued in court last time. It was inadvertent. I didn't mean to put the sealed information of Proctor's text message in a filing. It was inadvertent, and Judge Cannoni bought it. What lawyer files anything inadvertently? This has been the most strategic campaign all along. Following the court's corrective ruling to impound the witnesses' identifying information, defense counsel directly encouraged media outlets to continue to contact witnesses and ask them inflammatory questions in step with the defendant's theory of the case. See Karen Reed post-court press conference at the Norfolk Superior Court. Wow, I just have that handy. Shall we take a look-see at that? And thank you, Lally, for telling me exactly where it begins. I think he said 7:13, well, maybe a little ahead. Hold on one sec.
Stop. We didn't stop in there. We're not going to stop on this stair step. We're not going to stop when we reconnoiter tomorrow and in the weeks to come and in the months to come. This is now our fight. Karen's fight has become all of our fight for some sort of justice. My suggestion is you folks can play a part in this. Don't you want to ask some questions? I know you do.
I do. I have been.
I know you do. Let me give you some examples. Here's some questions that you might want to think about asking. Why did Jennifer McCabe Google search how long to die in cold at 2:27 in the morning, 3.5 hours before she would have any reason to believe?
Hey guys, why don't you go harass the witnesses? On behalf of Karen Reed about something you know nothing about. You haven't seen the evidence. You haven't seen how this is based on our totally wrong interpretation of the phone data. So much so that Cellbrite had to rewrite their whole program. But go ahead, just harass those witnesses. Harass them right on, straight on.
That John O'Keefe was dying in the cold in front of Brian Albert's house. How about that for a question?
He's covering up for him.
Why don't you ask the question, why did she scrub her phone? Why did she take the time to scrub her phone before she turned it into the police? Why did she delete any and all reference?
She never deleted anything.
To her communications with Brian Albert on the 29th, on the 28th. Why did she go to the efforts to do that kind of thing? Here's another question. Why did Brian Albert get rid of the dog? Why did Brian Albert get rid of the basement floor? Why did Brian Albert get rid of the house? They say that a fish rots from the head first. Let's start with Proctor, Michael Proctor, who's conflicted in this case because he has deep...
Well, the fish rots from the head first. Who would that be? I would say it's a psychopathic rotten head with Karen Reed. It starts there with the defense team. Then I'd say it's all one head, actually. It's a 3-headed monster psychopathic fish. Alan Jackson, David Unetti, and Karen Reed, and their fraudulent innocence fraud campaign. I mean, lying scam for a woman who will take no responsibility for what she did. In fact, wants to re-victimize the victim's family as much as possible. A common occurrence, common habit with innocence fraudsters. They love to re-victimize the victim's family, keep them in terror, keep them in fear, keep them silent. Not only does it give the killer great pleasure and a feeling of power, but it also silences the most powerful voice, a voice with a lot of knowledge of the case and the facts against the accused or the convicted. And a voice that will always elicit sympathy with the public. There can only be one victim, Karen Reed, for the defense. John O'Keefe must be demeaned, obscured, and boy, is ID Discovery doing that by their new mockumentary, calling it A Body in the Snow. A body in the snow. Why don't they just call it a thing in the snow? A thing of little import in the snow.
deep family ties to the very people that he should be looking at as a suspect. How about asking him a few hard questions? For instance, Brian Albert, why didn't you come out of the house? There is a police officer, God bless his heart, a dead cop on his front lawn, and Brian Albert couldn't find it in his soul to even walk out the door. Why was he hiding in the house? What was he hiding in the house? And just like he didn't come out of the house, ask Michael Proctor, the lead investigator on this case, why did he not ever go into the house? From that day to this, he has never set foot in that house. How about forensic investigation? How about trace evidence? How about bloodstain patterns? How about the evidence of a fight? How about evidence of a dog? How about that?
Emily is asking, is that Emily asking that? Emily Suzanne, will this doc be complimentary to Karen? Well, they've embedded themselves with the defense. It's strangely coming out 2 weeks before trial. It's on ID Discovery that has a history of doing innocence fraud. So I would, if I was a betting woman, everything about Bode's body says yes, of course it's going to be. With a cursory, it's going to present itself like it's going to look at both sides. But this is going to be an innocence fraud doc. That's my prediction. Hey, Tammie, thanks for being a member for a month. Thanks. Appreciate it. I was going to get a super chat, and then there's this. Nice to see you, Tammie. Thank you. I mean, can you imagine? They got to just hyping up the crowd, harass the witnesses, repeating again and again their talking points. Why was Chloe given away? Well, because she didn't get along with other dogs. Why did they sell the house? Because they did. I believe this is just ridiculous.
Those are the types of things that the Commonwealth doesn't want to answer. So now the cuts go from being from a dog to a cocktail glass in open court. It's funny how that morphs. You folks should be asking the hard questions. I know some of you are, and I know some of you will. Should be asking the hard question.
Wait, it goes from a what to a what? Hold on, let's go back.
The cuts go from being from a dog to a cocktail glass.
They go from being a dog. No one ever said they were a dog except the defense. No one ever said they were a dog but the defense. Some of them could be from the cocktail glass he was carrying. It really does, to my eye, look like they come from, some of them from the grating on the car grating of Karen Reed's taillight. But you see how they first they say they changed their story. How many times has the defense changed their story? It's the McAlberts, it's Colin Albert, it's Jen McCabe, it's Brian Albert. Now it's we don't know. Now it's Trooper Fanning messing with the jury, tampering with the jury. The jury really voted to acquit her of everything. I mean, how many fraudulent scam stories has the defense put out? I mean, that's just the tip of the iceberg.
In open court, it's funny how that morphs.
How about ARCA's unpaid? First they say ARCA's an unpaid independent witness who could have been used by the Commonwealth if the Commonwealth wanted. Now they say, yeah, we paid them. Yeah, we retained them, paid them, and scripted their testimony. Now the defense says that. Why don't you ask the defense about that? Why don't you ask the Bar Association why they're letting lawyers get away with this scam, fraud behavior? How about that, guys? Why don't you ask that crowd? Why is Yannetti and Jackson allowed to behave like this and poison the jury pool? Why are they allowed to make a mockery of the court in Denham, Mass? Why? And the people of Massachusetts, and make our court system look, our American court system look like a freaking kangaroo court.
You folks should be asking the hard questions. I know some of you are, and I know some of you will. We will not stop asking those questions. And by the way, we will get those answers. Come hell or high water, we will get those answers. And like David said, they're not going to like it when we do.
Ellen and
That's all
David,
for
if what you're saying is true, it completely undermines the confidence in police and the state. What would you say to that?
I'm not going to make any further comments other than what I've already said. I don't think the state has any confidence in their own case.
So those are some.
We have Boston police shit. A Boston fucking cop was murdered. And they have the nerve to show up opposing justice for a Boston cop.
Opposing justice, which is exactly what they're doing, opposing justice. And this is a defense and an innocence fraud campaign, always turning everything on their head. Let's take a look at the rolling rally quickly before. Actually, you know what? All right. All right. I'll try to go on the rolling rally for a little bit. I don't want to keep these too long. But here we go. Carney organized and publicized. This is from put up by Innocence Fraud Watch blog. Put up. This was to get Karen Reed's phones. She had 2 phones. Carney's organized and publicized a rolling rally where protesters would travel to the homes of witnesses in Commonwealth versus Reed on Saturday, July 22nd, 2023, at approximately 1200 hours. Carney departed Shaw's, 134 Nathan Street, Norwood. Oh, I know where that is. Accompanied by a number of motor vehicles. Carney began a YouTube Live video. YouTube Live allows users to broadcast live videos on YouTube platforms, which can be later saved and distributed on a user's account. At the beginning of the video, Carney is operating a motor vehicle and stated at least 200 people are in the caravan of vehicles. He further stated he did not broadcast the locations of the protest prior to the departure of the rolling rally. He stated the addresses of the first location, 909 Washington Street, Norwood, Mass., which is the residence of Brian Albert. Brian Albert was with John O'Keefe in the hours before he was killed, and O'Keefe was found unresponsive on the front lawn of Brian Albert's previous residence at 34 Fairview Road, Canton. During the video, Carney stated the purpose of the rally is to protest to protest a murder cover-up and framing of an innocent woman. He stated some witnesses will be in jail within a year and brags about being able to locate the witnesses wherever they travel. During the duration of the rally, he thanked the other members of the rally for attending. The residence at 909 Washington Street, Norwood, is the primary residence. Oh, wait, maybe I shouldn't read this out. Sorry. I'm so dumb to read this out. Forget everything I just said. Of Brian and Nicole and their children. I hope this doesn't create any more harassment. I won't read out any more addresses. The Alberts were aware of the rally and had vacated their home to avoid harassment. At approximately 12:18 hours, Carney arrived at Albert's residence. The residence is an apartment-style building. Carney gathered the protesters adjacent to the building. When he arrived at the residence, he used a megaphone, which allowed the amplification of his voice. Carney described the Alberts as murderers who were in hiding. Carney used the megaphone to make claims that Albert was involved in the murder of John O'Keefe. Carney spent approximately 3 minutes outside of the Alberts' residence. In the days leading up to July 22nd, cameras were placed outside of several of the locations where protests were scheduled to occur. Below is a still photo of the video from July 22nd at 12:22 hours in front of Brian Albert's home. Michael and Elizabeth Proctor live at blank with their 2 young children. Michael and Elizabeth Proctor were not working on this Saturday. The Proctors purposely vacated their homes and made plans to avoid the protest. When Carney arrived at their home, they continued to use the megaphone and stated the Proctor was framed. So you get the idea that he was a disgrace. They went on to Matthew and Jennifer McCabe's home. And during the rally, Matthew, Jennifer, and their 2 children were home. Prior to the rally, Carney had posted pictures of the McCabe on vacation and made statements that Carney can find the McCabes wherever they live. So that'll give you an idea. I mean, they just went from witness to witness's home. Here's another picture. So I've gone over this before, but Natalie Wawicki Bernschneider was the middle woman. She had gone to Bentley University with Karen Reed. She was not close friends with Karen, but had friends in common. Following graduation, Natalie returned to California and lost touch with Karen. And after she heard of John O'Keefe's murder, Natalie contacted Karen to offer support and began a friendship. Natalie noticed, and Jen Ottman was someone who was always supporting Karen Reed on Facebook and enlisted her in this campaign. And then it was Natalie Wawicki Bernschneider who got Karen in touch with Aidan Carney. And so they communicated through Natalie in the beginning. And then they eventually started talking directly, leaking. Okay, so on several occasions, the nature of the relationship between Karen, her defense attorneys, and Carney is discussed. In one such exchange on May 7th, Carney stated he disagrees with Alan Jackson's theory, of which O'Keefe was allegedly moved to the front lawn. Carney wrote, "Keep in mind, Karen, AJ, and myself don't officially talk. It would be normal for me to have opinions that differ from the defense, although we all agree that Karen had nothing to do with it. I made it clear that my theory of how he died is simply that, a theory. If there's more information I haven't been given that can prove my theory is wrong, I'm all ears." Yeah, well, he's been proved wrong and he sticks with it. Natalie responded, "I hear you, Aidan. It's good not to be completely in sync. We are open to other theories." In public settings, Carney and the attorneys for Karen Reed had denied communicating or mischaracterized the nature of their communications. A check of the text messages from Natalie's phone reveals several instances where it appears Carney communicated directly with attorneys Jackson and David Yannetti. The first being on April 22nd, 2023. Natalie sends Carney a message, "Did you talk to AJ today?" And Carney responded, "Just saw his text, gonna call him in a bit." They have lunch. David Yannetti and Carney, Alan Jackson, David Yannetti, and Karen Reed all have lunch at the Omni Seaport on May 3rd, 2023. A check of the phone revealed one of the first text messages. Carney, Natalie stated, Karen and her team will be likely convening at the Omni Seaport after the May 3rd hearing. I'd be happy to meet up with them. And then Natalie sent Carney the message, Turtle can meet Alan on Tuesday, May 3rd, perhaps. Natalie stated she spoke with Carney following the May 3rd court hearing. Carney stated he was nervous to attend lunch with Karen and his attorneys as he would feel out of place. Natalie reassured Carney he was welcome, and it stated it was good opportunity for him. Carney agreed and stated he was going to attend the lunch. Carney sent Natalie a text message at 6:28 p.m. stating, we had a great time. Natalie would later mention Carney having a nice time at the lunch. It should be noted that at all times, Natalie was in California, did not attend any Reed court dates, and was relaying messages from Karen to Carney. On May 2nd, Natalie sent Carney the message, Colin has a lawyer, ask Yannetti about it. On May 5th, Natalie sent Carney the message, tell Turtle Boy from me, be strong, Aiden. So that's Karen talking. Get down for a day, but wake up and keep fighting tomorrow. Please call Alan and spitball your issues with him if you want to. Nothing gives you a shot in the arm like talking with AJ. Natalie later asked, did you call him? And Carney replies, just did. On several occasions, the nature of the relationship between, in public settings, Carney and the attorneys for Karen Reed have denied communicating or mischaracterized the nature of their communications. On September 27, 2023, Boston Magazine, meaning Gretchen Voss, published an article about the homicide of John O'Keefe and Karen Reed's defense. For the article, the author, Gretchen Voss, interviewed Karen, her attorneys, and Aiden Carney. The article describes Carney's involvement in the case from April through July 25th. Court date. After describing how the author interviewed Carney at his residence, the article states both Carney and Reed's defense team say they have never been in contact with one another. On October 20th, 2003, and why didn't Gretchen Voss clear that up? Why didn't she correct that for accuracy and clarity? On October 20th, 2003, an X account, formerly Twitter, associated with David Yannetti, Boston Defender, posted a response to another post alleging Yannetti tipped off Carney about the story. See, don't you think this story, my theory is the story came from the defense. They had this story written. The post in part reads, he, Carney, and I never communicated until after his first piece on the Karen Reed case. I observed text messages between Natalie and Carney containing discussions about an investigation being conducted by the FBI and U.S. Attorney's Office. On one such occasion, in an April 23rd message sent by Natalie to Carney, quote, not public. The feds have been involved longer than anyone is likely guessing. On April 28th, Natalie sends Carney the following message, but I don't understand why he doesn't mention more than the feds are involved. The first U.S. attorney, they don't shoot and miss. They have a case and way more evidence than we do. I know this for a fact. Jen McCabe testifies this coming week. I'm not sure about the others. Carney responds later on April 28th. Has there been any new information about the FBI investigation and handing out subpoenas? Natalie responds, no new info, just that they're already present the case, the GJs as we speak, and DA's office has been informed. This is confirmed 1,000%. In a later exchange, in April 2023, the Norfolk DA's office was notified by the Boston Attorney's Office that witnesses involved in the Commonwealth versus Reed were served with subpoenas for a federal grand jury. So GJ is grand jury. In a later exchange, Natalie wrote to Carney, bingo, was in reference that you go to the names of the U.S. Attorney's Office. And Carney responded, oh, she spoke to David, I'm guessing. On May 5th, Carney stated he had heard a rumor 20 FBI agents were seen in Canton for possible arrests. 2 days later, Natalie sent Carney a message that contained, in part, not public. Levy confirmed no swarms of FBI agents were in Canton 2 days ago. The reference, okay. And on May 3rd, while in open court before Judge Cannoni and television cameras, attorney Alan Jackson reported federal authorities have now gotten involved in circumstances surrounding this case and have impaled a grand jury, a federal grand jury, to investigate some of these circumstances. Following the court hearing, Alan Jackson, David Unetti, and Karen Reed spoke to the media on the front steps of the Norfolk Superior Court. The Commonwealth later filed a motion requesting Reed's defense attorneys refrain from making extrajudicial statements. So, just, Carney denies ever having spoken to Karen Reed. He described how a follower of his blog connected him with a friend of Karen Reed, which is how he received his information. Carney appeared on a live show, New Bedford Live, at the 37 mark. Carney asked if he's ever met Karen Reed. Carney responded, I've seen her in court. I've never met her family. I've talked to them, not every day or anything like that, but I've had pleasant conversations with them. But Karen likes to keep a distance. This is like when he was talking to her every day. Several text messages exchanged suggest Carney and Karen communicated directly without Natalie acting as an intermediary. These messages are in addition to the previously mentioned messages asking Carney to check his Signal, meaning Signal app, which is an encrypted app. One exchange on May 6th involves Carney disbelieving a portion of Karen's defense and is frustrated. He texts Natalie that he tried calling her, meaning Karen Reed. Natalie asks 15 minutes later, are you guys on the phone now? And Carney responds, yes. Right, I'm going to take a quick break. I will be back in 1 minute. Hey, Tammie, when does AJ get the boot? I don't know if he's ever going to get the boot. Just because of, I think Cannoni doesn't want to delay this trial. But I think that the court should be, I think that the California Bar Association, anybody can write a complaint to the California Bar Association about this kind of behavior. I think they should hear about it. I think they all should be given the boot, but that would delay the trial, like about a good 6 to 8 months to a year and a half. All right, I'll be right back. Don't go anywhere.
A glass of wine. Roberta will be back in no time. This podcast is listener supported, so smash that like button and subscribe or become a patron for exclusive content if you are so inclined. Have something to say? Shoot Roberta a super chat. She will do her best to read it all air. With without delay. Now Roberta's back and ready to put the true back in true crime. Here's Roberta.
Okay, we are back. So there's just many calls between communications between Karen Reed and Aidan Carney, and then Aidan Carney and phone calls made directly to and from Alan Jackson and David Yannetti. A check of phone records from Carney's phone revealed communications associated with phones. Here, let me show you. It's right here on 72 on page 23 of 31. A check of the phone records from Carney's phone revealed communications with cell phones associated with David Yannetti and Alan Jackson. A phone number ending in 5359 was checked through LexisNexis, a commercially available database, and was associated with David Yannetti. So David Yannetti communicated with Aidan Carney's phone, two phones. He had two phones. So Turtle Boy had two phones. 29 times David Yannetti communicated during this time period, including 9 times from April 20th to May 2nd. A phone number ending with 0555 was checked through LexisNexis and associated with Alan Jackson. Alan Jackson's phone number communicates with Carney's two phones 29 times, including 3 times from April 20th to May 1st. So this harassment of witnesses, I mean, the only logical conclusion is that her defense lawyer's strategy was, and you can hear Alan Jackson encouraging people to ask questions, meaning harass witnesses, was to harass the witnesses in this case. Kind of amazing, no? I mean, the fraud is off the charts. And the Free Karen readers felt that the feds were going to come and arrest Jen McCabe and the rest of the witnesses in this case any minute. So that's where I'm going to leave it for today. I don't want to run too long. I will be back tomorrow. I have off, but I will be back Tuesday at 6 p.m. Have a great night, everyone. Thanks for listening.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mom. My innocence fraud campaign is my biggest hit yet. system, my clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, carry.